Good morning, afternoon, or evening. Your video is about to start. I wanted to remind you of our newer Wednesday, 1 p.m. live stream Q&A on all things Social Security. Visitors are welcome to post a question in the chat, and I'll do my best to answer it. It's on a first come, first serve basis, so please get there on time. Otherwise, if you care to be a member and get some different kinds of perks, feel free to click the join button below or just click it to learn about them. Anyway, I hope to see you Wednesday. If not, enjoy the video. Bye now. Good morning. This is answering a concern. I hear it fairly often, and it often comes up when someone is undergoing a CDR. You might be aware that sometimes it's hard to get a representative to represent you when it's a CDR. I don't typically do them anymore either. Not to say I never wouldn't, I never would, but it's not really a viable business addition to a practice in order to keep the doors open because of the SSA rules regarding fees and all that. So in any event, so the idea goes like this. You have been getting SSDI, you get a notice of a CDR, you perhaps lose the initial determination and your benefits are going to be stopped, but you smartly appeal, which is a 60-day time limit. But you also, because you need to, if you need to, file that very short-winded deadline date for the please keep my benefits going pending this appeal. Don't stop it. I need it while I'm fighting this appeal and I'm in the right. That little request to have your benefits continue pending appeal has a very, very short leash of a deadline. It's like 10 days. And if you get your determination on day 9 or day 11, you might be screwed, so to speak. I think the letter might say that 10 days goes from the date not on the letter, but the date you receive the letter, and they will presume that you received it within 5 days of the date of the letter. So something to just double check. Make sure you look to see if it gives you that extra 5-day language. So at least then you get technically 15 days from the date of the letter. But in that time frame, you have to get them notice that you wish to continue your benefits pending your appeal. And I don't think it should be that you have to have your appeal in that time at that time, because maybe that takes you a little bit more time. But generally, people tend to do them together. So you really have to hurry. So if that happens and you succeed, and now you're continuing your benefits, but you're fighting this CDR, and particularly, I mean, I always say get your attorney right away if you've lost the first round, because you're going to want their advice as to what you might not have been doing that you still might have time to do to turn that around. And if you wait until you get denied again on recon, now you're heading towards a hearing. And a lot of attorneys won't take your case on such short notice because by the time they get access to the file and everything else, sometimes the hearing is right around the corner. And for those of us that really relish the idea of giving our clients sound advice they can act on to improve their evidence for a greater chance of winning versus just showing up at the hearing, sending in some medical records, woo. Um, for us, we want to get in there as early as possible because then we can do more for you and you can do more for yourself because you're going to know what you need to do. So if you're at that point, you've been collecting your benefits and now you're denied and you're either heading into recon or heading into an ALJ hearing, the question is, will I get an attorney when I don't have any back benefits from which they will be paid? That's the downside of continuing your benefits. However, most people continue them because they need to continue them. They don't have alternative income or maybe a very successful working spouse or other form of income that they can rely on. So I typically see people want to collect their benefits pending the appeal, and it's totally understandable. So what's the alternative? If you find someone who will take a CDR, and I don't know, I should rethink it, but that's a topic for another day. They will probably ask for a retainer then. It's something that we don't generally do because we rely on the back benefits as the pool from which the SSA will take the fee to pay the attorney once they approve a specific attorney fee. And that is only generally if the attorney's case prevails for the claimant. So, what is this retainer? And you hope you have it, right? I don't know what other people do. I would say I would probably be requiring at least $5,000. It's something you might want to prepare for in terms of creating a savings account little by little over the years to have that. I know that's not that easy when you're on a fixed and limited income and can't hop back into the job market. There is sometimes opportunity for a smaller initial retainer, but then every month putting forward a certain amount towards it with your prospective benefits that you are collecting while you are pending this appeal, which has created the whole problem about the back benefits. So there is different ways to skin that cat, I think. I think a lot of practitioners who do CDRs would be willing to work something out like that in terms of they ultimately want at least X retainer, but they might be willing to take a smaller upstart and then every month you need to, maybe send them $300 or $500 or whatever it is. It's really going to depend on the situation, I suppose. But I I don't think it's a bad idea to always in an interest-bearing account, maybe a high interest savings account where you keep, every $50 from every benefit check goes in there just to start growing some sort of little nest egg for that potential emergency of sorts. 5,000, could someone do it lower? I'm sure they could. Um, I think it's probably just gone up over time. I mean, inflation has been so bad. Everyone's benefits have increased accordingly. So finally, the attorney's fee cap has increased. And not that, all cases are going to end up paying as much as the cap, but it tends to be a curb at times. Um, so I would expect that the level of retainer that would be sufficient to make a attorney or a non-attorney rep comfortable representing and knowing they're not going to get completely in the red would be increased also. So maybe we used to do 3,000, maybe it's 5 or 6 now. I don't know. I mean, it depends. So just give it some thought. It might be worthwhile preparing for that over the course of time while you're collecting. Just conserving in whatever way you can, or if you're working part-time while you're collecting and doing so within the confines of the rules, that might be a way to also save that. But just something, because otherwise you might very well have an impossible time getting an attorney rep or a non-attorney rep on a case where there is no case, no way to collect a fee when they succeed in overturning your denial. Okay. All right. I hope that helps. I know it's tough. It's tough all the way around, but that's kind of the basics for you on the considerations that we go through and what you might end up going through if you get a CDR, get denied, and want to keep your benefits flowing while you fight that appeal. All right. I'll talk to you later. Bye.